just press that. Great. Thank you very much, Jeffrey, and thank you to Simone and to Aisling for inviting me to talk here today about this particular topic. You have actually the slides in your pack, so I'm not going to go through all of the slides. I may skim through some of them for reasons of time, but the topic, I suppose, today relates to civil partners, parenting and the law, and the question really is whether or not joint adoption is the solution in this context. The purpose of the paper is to address the legal position of children being parented by civil partners and other same-sex couples, and in particular what I want to do is to consider the scope for improving the legal recognition of social or de facto parents through adoption and guardianship law reform, always with due regard to the obligations and rights of biological parents. Now, what do I mean by social or de facto parents? Well, we're talking here basically about people who are parenting children but who are not the biological or adoptive parent of a child. In other words, where they are effectively in loco parentis, or they are parenting along with a biological or adoptive parent of a child, but they don't have a legal relationship with the child as such. And in particular, I suppose, in the context of same-sex couples who are raising children, almost by definition, you're going to have one biological parent or adoptive parent and one social or de facto parent. And as we'll see, the legal rights and obligations of those persons of the couple differ significantly based on whether or not they're a biological or a non-biological parent. The guiding principles, I think, are important in this regard. I suggest that there are a number of points one has to take into account here before proceeding. Firstly, there is no right to adopt as such, either under Irish or international law. Nobody has a right to adopt under the Constitution, or indeed under the European Convention on Human Rights. The key criterion in all of these cases is the best interest of the child. This is the paramount consideration, and so a child-focused approach is required in examining this issue, and it is always important to place the child at the centre of the discussion. That's not to say that issues such as discrimination on the basis of sexual orientation should be ignored, but I think it is important to bear in mind that this is not an adult rights issue, it's a child's rights issue, and in particular the child's relationship with all of the people involved in parenting the child should, I suggest, be valued and facilitated in a manner that promotes the best interests of the child. The law should in particular help foster stability and security for the child in the environment in which he or she is being lawfully raised. Now, in relation to parenting by same-sex couples, this is often presented as an abstract issue, but it isn't. Children are already being raised by same-sex couples. Census 2011 enumerated 230 same-sex couples raising children together. Now, most of these, the vast majority, were female or lesbian couples. This is out of a total of 4,000, just over 4,000 same-sex couples that were enumerated. There were 230 raising children together. It's a small number, but it is nonetheless significant, and it will more than likely rise in the future, particularly given that the average age of civil partners appears to be dropping this year as compared to in 2012 as compared with 2011. There are possibly also many other lone LGBT parents, people who are lesbian or gay, raising children on their own. And if you look at, I suppose, the US, you see there are 110,000 plus same-sex couples raising children in the US, according to the Williams Institute in 2012. And many of these couples, in fact, came to become parents through adoption. Now, the pathways to parenting for LGBT parents, LGB means lesbian, gay and bisexual parents, but we're talking here about same-sex couples raising children. There are a number of different pathways. The children involved may have been born as a result of a prior heterosexual relationship of one of the partners, I should say. The child may have been born, particularly to a lesbian couple, following donor insemination, and this is, in fact, it appears certainly anecdotally, this is becoming more common that lesbian couples are choosing as a couple to have children following donor insemination. This may be formal through a clinic, or indeed informal with an acquaintance who agrees to assist the couple in having a child. Surrogacy is a live issue for both heterosexual and same-sex couples, but it's a tricky area, certainly ethically, legally. It is an area that's fraught with all sorts of difficulties, and I don't want to deal with it in too much detail tonight, but there is a very good guide on the Department of Justice website to the law in this particular area. It is also possible that one of the civil partners or cohabitants may adopt as a sole adopter, but as we'll see, it's not possible for a same-sex couple or civil partners to adopt jointly. And it is the case already that some same-sex couples are fostering children. Most of these, again, are female couples, but it is possible, although a same-sex couple cannot adopt together, they can foster together. That may be as a result of the numbers, the demographics involved. The number of children available for adoption in Ireland is very, very low, but the number of children who need foster homes is very high relative to the number of foster parents. So perhaps it's not surprising that the state has turned to lesbian and gay foster parents as well. Now, I think it is worth, I suppose, addressing the issue that does arise in this context quite a bit is same-sex parenting in the best interest of the child. Are there good outcomes as a result of same-sex parenting? And certainly there are diverse views on this point, and the issue, I suppose, is debatable. Certainly the research that I have consulted suggests that family form, the form that a family takes, and parental sexual orientation and gender do not significantly affect outcomes for children. And in particular, I would refer to the US National Longitudinal Lesbian Family Study, which has been ongoing since the 1980s. This is a study that's been following children being raised on a planned basis by lesbian couples, and they have found that there is no difference in psychological well-being between children in planned lesbian families and those in heterosexual two-parent families. And in particular, of most note, a report from last year suggested that the absence of male role models did not affect psychological well-being in teens in this particular context. The American Psychiatric Association, reviewing a series of studies, suggested that there is no evidence of disadvantage to children parented by same-sex couples in terms of emotional or psychological development, and the longitudinal study, I think, has borne that out as well. In fact, the longitudinal study suggests that it may well be the case that children raised by lesbian couples have fewer behavioural problems and more competencies. The quality of family process, it is suggested, and the quality of family relationships are more important determinants of well-being than the form a family takes. And this is borne out by Irish research that I don't believe has looked specifically at same-sex couples raising children, but Fahy and all growing up in Ireland, and earlier research has suggested that well-being depends mostly on family process, the quality of family communication in particular. It's worth noting, as I suggested already, that same-sex couples are allowed to foster together in Ireland already. And indeed, the government, during the debates in the Adoption Bill 2009, has suggested itself that it doesn't have any principled objection to gay men and lesbians as parents. Barry Andrews, TD, the Minister for Children, during the debates, said that gay men and lesbians make very good parents. The argument that same-sex couples cannot be good parents is contrary to the case, and indeed there is certainly plenty of research that bears this out. Now, civil partnership is with us now. I think it's just over 2 years. The Civil Partnership and Certain Rights and Obligations of Cohabitants Act 2010 introduced a new status available to same-sex couples only. It's important to note. Since 2011, there have been 965 couples who have entered into a civil partnership in Ireland. Now, civil partnership is substantially similar to marriage in most respects as regards the relationship between the adult partners. However, the Act largely sidestepped the legal implications of parenting by same-sex couples. While there is some reference to children in the legislation, by and large the 2010 Act did not address what was perceived to be the thorny issue of same-sex couples raising children. It certainly hasn't made things any worse, but it didn't improve the situation for same-sex couples raising children. Now, in relation to parenting rights and obligations, I do just need to mention very briefly, and many of you will be familiar with this, the concept of guardianship. Guardianship involves the right to make major decisions about a child's upbringing, in particular its education, its religion, if any, whether or not the child will be adopted. Guardians must consent to an adoption. Whether a child is issued with a passport, the guardians have to consent, and whether a child undergoes medical treatment. Now, generally speaking, guardianship is confined to the biological parents of the child, and I've set out on the handout the rules that apply in this context. But basically, guardianship is generally speaking confined to biological parents of the child. The mother is automatically a guardian of the child where the parents are married or not married to each other. Where parents are married to each other, the father and mother are joint and equal guardians. Where the parents are not married to each other, the mother is automatically a guardian. The father is not automatically a guardian, but he may become a guardian either by court order or by agreement between the parents. As regards people who are not biological parents, the situation is very different and quite precarious. A person who is not a biological parent may only acquire guardianship by adoption, by will or by court order on the death of an existing guardian, or exceptionally by court order on the removal of an existing guardian. There is effectively no mechanism in Irish law, and this is a key point, whereby a parent and their civil partner or same-sex cohabitant may simultaneously share guardianship obligations and rights in respect of a child. And so while a couple may be parenting together, there is no legal mechanism to facilitate, if you like, both of the parties having shared parental responsibility. And this has an impact for the child and for the non-biological parent. If I can use that term, basically I'm talking about a de facto or social parent, someone who's not a biological parent of the child but who is raising the child along with their partner, faces a number of legal difficulties. In particular, the non-biological parent has no obligations and very few rights in respect to the child, and in particular they can be excluded from important decisions relating to the child. They are not obliged to maintain the child. There's an exception in relation to step-parents, but a civil partner or a cohabiting same-sex partner is not obliged to maintain the child of their partner. The non-biological parent cannot seek custody, veto an adoption, or prevent the removal of the child from the jurisdiction. But by the same token, the child has no rights in respect of the non-biological parent. In particular, the child can't seek maintenance from the non-biological parent. The child cannot make a claim against the non-biological parent's estate in this context. And so, broadly speaking, we have a situation where the non-biological parent has few rights but no obligations towards the child. And arguably the failure to address the legal aspects of co-parenting by civil partners has relieved one of the civil partners of obligations that would in fact be quite beneficial to the child and the state to recognise. That it's not in the interest of the child, or indeed perhaps the interest of the state, not to recognise that there is a relationship here that should be formally recognised. Now, there is some limited recognition for non-biological parents. For instance, a non-biological parent, if they have been in a position of loco parentes, they've been looking after the child, they can seek access rights in respect to the child if the couple are separated. They can obtain barring and safety orders for the child's protection, and they can also take parental leave to care for the child if they're in loco parentis. And indeed, the relationship between a person and the child of her civil partner is also recognised for tax and social welfare purposes. So if you give a gift or an inheritance to a child of your civil partner, and specifically the child of your civil partner, the child will be treated as if they are your child effectively for tax purposes. And a similar principle apply to social welfare. In relation to ethical conflicts of interest, the relationship between a child and the child of their civil partner is the relationship between a person and the child of their civil partner is also recognised. The precarious legal position of same-sex couples parenting a child was illustrated by the decision in J. McD versus L and M. And in this particular case, there was a dispute between a lesbian couple and a man who had assisted them in starting a family through sperm donation. Now, he initially agreed that he would have contact with the child, but would otherwise play no part in parenting the child. But subsequently, he sought access and guardianship in respect to the child. This was refused in the High Court on the basis that either order would disrupt the de facto family life of the couple and their child. Mr Justice Hedigan notably concluded that the couple and their child were a de facto family for the purpose of Article 8 of the European Convention on Human Rights, and that as such they had rights that needed to be protected. However, when the matter came before the Supreme Court, they reversed the High Court ruling and granted the father access, but not notably guardianship. They ruled that the High Court had erred in regarding the couple as a de facto family, either under the Convention or under the Constitution. They said effectively that the couple was not a family for the purpose of Irish law and enjoyed no legal recognition in Irish law at that time, and this was pre-civil partnership. It's notable that the European Court of Human Rights itself has moved beyond that. In Schalkenkopf and in Gasson-Dubois, they have recognised same-sex couples and same-sex couples with children as enjoying family rights under the Convention. The Court pointed out in particular that the partner of the mother had no constitutional and few legal rights in respect to the child. The Court ruled in particular that the High Court had placed too much emphasis on the child's relationship with the couple and hadn't sufficiently considered the benefit to the child of having contact with its father. The decision, to my mind, reflects a largely biologically focused approach to parenting and family formation, that the focus in Irish law is still very much on biological parenthood, and there's a complete failure to engage with issues of social parenthood. Although it is worth noting that Mrs Justice Denham in particular, as she then was, pointed out that notwithstanding the fact that the couple are not a family for the purpose of Irish law, there is nonetheless some suggestion that the role and contribution of the couple in raising the child is an important consideration. Ms Justice Denham pointed out that the circumstances of the case show that the respondents have lived together for years in a loving relationship and they provide a settled and loving home for the child. And these factors are of critical importance in assessing the welfare of the child, so they weren't entirely ignoring the environment, the home environment of the child. Now, moving along to adoption, it is important to note that stranger adoption in Ireland, adoption by people who are not related in some way to the child, is quite rare in Ireland. Most children are adopted by people already related to them or to a parent. A parent and a new spouse is one classic example of the kind of adoption that one might have in Ireland, where a step-parent and the parent of a child together adopt the child so that they can become effectively a couple with recognised rights in respect to the child. Now, it's important to note that the number of children available for adoption in Ireland is low, and that most people applying to become adoptive parents in Ireland are applying for declarations of eligibility and suitability so that they can adopt abroad under the Hague Convention. And of course, many of the sending Hague Convention states don't permit same-sex adoption for ideological reasons. Now, in terms of eligibility to adopt, for domestic adoptions and inter-country adoptions affected by Irish resident persons, the following are eligible to adopt. A married couple who are living together are eligible to adopt. The mother, father or relative of the child are also eligible. But in addition, a sole adopter who is not a relative of the child or is not the mother or father of a child, where the adoption authority believes the adoption to be desirable and in the best interest of the child, and it's an important caveat, a sole adopter can adopt. My reading of the legislation is that this does not preclude civil partners or people in same-sex relationships from adopting, but it's important to note that a same-sex couple or civil partners cannot adopt jointly. Effectively, unless they're a married couple living together, it is not possible to adopt jointly. But nonetheless, the legislation does allow sole adopters who don't fit within the other categories to adopt, provided that the adoption is desirable and in the best interest of the child. Now, a married person may also adopt as an individual, and that person's spouse must, however, consent unless certain conditions apply, which I've listed on the handout. Now, it's important to note that as a result of the decision in EB against France, where individuals are allowed to adopt as sole adopters under the European Convention on Human Rights, a state cannot discriminate against a prospective adopter on the basis of sexual orientation. Now, there's no obligation to allow sole adopters to adopt, but where a state does allow individuals to adopt on their own, a state cannot discriminate against the person, rule them out of the running on the basis of their sexual orientation. Now, About 5 minutes, okay. Yeah. There is effectively no bar in Ireland to people who are lesbian or gay thus adopting as sole adopters, provided that they are otherwise suitable. But nevertheless, a couple wishing to adopt in Ireland must be married to each other and living together in order to effect a joint adoption. And a similar principle applies to an Irish resident couple wishing to be declared eligible for an inter-country adoption recognised in Ireland. They can't be declared eligible to adopt abroad as a couple unless they're married to each other and living together. Thus, in Irish law, same-sex couples, even whether in a civil partnership, cannot adopt a child as a couple, either domestically or by means of an Irish country adoption, an inter-country adoption. So the position, to put it in a nutshell, is that a civil partner or a person in a same-sex relationship can adopt, it seems, as a sole adopter, but civil partners can't adopt jointly. There is a question, I'm not going to go into it in too much detail now, but there's a question as to whether or not adoptions that are effected in other Hague Convention states by same-sex couples who are not resident in Ireland can be recognised in Ireland, and there seems to be, as well, some question mark over this. On the one hand, the Hague Convention does require mutual recognition, at least, of inter-country adoptions that are lawfully effected in other Hague Convention states, but this is subject to public policy considerations. So the question is whether or not joint adoption by civil partners or by a same-sex couple in a foreign state would be contrary to public policy, and this may ultimately have to be determined by the courts. Now, I've set out on the handout actually a situation in England and Wales and Northern Ireland, but I don't think I have time to go into it, so I might just skip to the end. But it is detailed there on the handout, and I'm happy to answer questions about it. The question I suppose I want to ask ultimately is whether or not joint adoption for civil partners and same-sex couples is the solution. And it's arguable certainly that it provides a more stable foundation for family life. In particular, it respects and potentially buttresses the integrity and unity of same-sex families. The child in particular acquires rights in respect of both parents, which provides arguably greater stability for the child. And in particular, it allows both of the parties, or would allow both of the parties, to make decisions in respect of the child. There is also the advantage for the couple that the adoption terminates any pre-existing rights and obligations of biological parents. The adopters assume full parental rights and obligations with no risk of interference from others, and this can be to the advantage of the couple as they see it. But there are also complications with adoption. Adoption is not a straightforward remedy. It's time-consuming and bureaucratically complex, and with good reason. It may well not be suited to situations where a couple are seeking to formalise a relationship with one of the couple's children. It's worth noting that adoption can be blocked by the mother of the child, by other guardians, or by persons with charge of or control of the child immediately before the placement. So if you don't get those consents, the adoption may be blocked. And indeed, pending the implementation of the Children's Rights Amendment, children born inside marriage still cannot be adopted as things stand at the moment, although that undoubtedly will change. Joint adoption for civil partners certainly will be a welcome step, but I argue that in many cases allowing the civil partners and spouses of parents to acquire guardianship would provide a simpler, less intrusive mechanism where one of the civil partners or spouses is the parent of the relevant child. So effectively extending guardianship is the solution I'm suggesting here, that this would confer parental responsibility, in particular without affecting existing guardians' rights, which might be important from the point of view of other parents of that particular child. Now, it's worth noting that the Law Reform Commission has recommended change in this area. It has suggested it has proposed allowing a civil partner or spouse of a parent to be given parental responsibility, which is effectively guardianship, either by written agreement with the other guardians or by court order if it's in the best interest of the child. And indeed, the Minister for Justice and Equality appears to favour reform in this area. On two specific occasions he said that he is in favour of, and perhaps is even currently drafting legislation in this area. So this suggests that there is an impetus for guardianship law reform that perhaps may not exist in respect of joint adoption. I don't sense that there is great enthusiasm in governmental circles for joint adoption, but certainly there is some encouraging signs around guardianship law reform. So in conclusion, and thank you for bearing with me, I perhaps have too many slides, there is a need for greater recognition and support for de facto parenting relationships, not just by the partners of parents, but also by, for instance, grandparents who are looking after children and other family members who may be caring for children. There's no mechanism effectively for them to become guardians, and this places them in a very precarious situation. There is a compelling case in particular to allow civil partners to adopt jointly, particularly given that they've made a solemn commitment to each other which is legally binding. It is arguably illogical to allow a child to be raised by a couple, only one of whom has parental responsibility, where both are willing to be parentally responsible. Nonetheless, I suggest that the extension of guardianship may provide a simpler, more effective route to joint parental responsibility. In sum, I think it is important to ensure that to the greatest extent possible and subject to the best interests of the child, that stability and security is provided for the child in the environment in which he or she is lawfully being raised. Thank you for your time.